Hello, good afternoon. This is Mr. Ayazuddin S Khan from Pune, Maharashtra State, India. I have come here again. Yesterday I was there with you with video number 7 about non-resident, not ordinary resident, not resident Indian and resident. During that video, I completed all my lecture, but at the end of the lecture, when I was discussing the resident Indian, that time abruptly there was some technical problem and video stopped working. So what happened, that discussion was incomplete. So I thought it proper to have further discussion on that topic, rather that the entity resident. So it is not independent video describing some basic thing. It is, you please see this video in continuations of my earlier video, that is video number 7 on non-resident, etc. So now I will start with this non-resident. Non-resident is a person, I have to talk on resident. We have non-resident, we have completed. Resident portion only remaining. So let us have discussion on this resident. A resident, as per Income Tax Act 1961, it says a person, you can call him as a resident. A person you can call, or you call him as a resident if he is in India or his stay is in India up to 182 days or more. This is first test. First test is like this. You count his stay period in India. If it is 182 days in India in the previous year, remember this previous year, we are finding out the status of an individual, whether he is resident or otherwise, only with reference to previous year. Status, normally we decide, or there is, as Income Tax Act says, we should decide his status, one's status, only during previous year. That you have to remember. Previous year, we have to find out one's status, whether he is a resident or otherwise. So, Income Tax Act 1961 says to find out the status of individual, whether he is resident or otherwise, it says the individual is resident in India if he stay in India in the previous year, relevant previous year, is for 182 days or more. Okay, this is first test. Now, some explanation for this first test or thing to be remembered as far as this first test is concerned, that his stay period should be in the previous year, his stay period should be 182 days. Here the Act says that period of 182 days should not be continuous one. It should not be continuous one. It should not be continuous one. 1 to 180 days. Like this, he should not be here. He may go here and there. He may come and go somewhere, and he will again come back and stay here. So his total stay period, we have to consider total stay period, coming, going, and then that coming going results into some stay, isn't it? So that Act says you count that period, total continuous period. It may be in batches. It may be in batches. So that total period you take into account and find out his status. If his total period of stay in the previous year, not continuously, but a small period or short period also, total short periods, first short period, second short period, third short, any number of periods. If he is in India, total of those short period you take into account, and if it is 182 days or more, then you call him as a resident in India. Resident in India. Okay. This is first test to decide whether he is resident in India or not. Okay. Then the Act says, rather gives or prescribes another second test for deciding his status as a resident in India. And what is that second test? It says if that individual stays in India for 365 days, if that individual stays in India for 365 days or more, if he stays in India for 365 days or more, listen now, during last 4 years, during last 4 previous years, remember this carefully, if he has been in India, if he is in India for last 4 previous years, relevant to the previous year for which we are deciding his status, residential status, whether he is resident in India or not. So, this is this thing to be remembered. If he has been in India for last 4 previous year, relevant to the previous year, for which we are deciding his residential status. This way we have to understand. And Act further says, not only this much, you go ahead and also find out his stay period in the previous year proper. It should be 60 days or more. It should be 60 days or more. So, this is the second test. So, we will rather understand this second test by taking example. Because definition of this resident or this what you call the second test that Act gives us to find out his individual's residential status, that second test should be properly understood. And if suppose we get some example to understand this thing, it will be convenient to remember this thing. Otherwise he actually, for newcomer, it is the test to keep this test in mind. It is some sort of torture-giving test to memory. It is torture-giving test to your memory, to new learner. I am talking about new learner. Otherwise, all can have a rough idea about this second test work, and they can refer the Act within no time and find out everything, whatever you want to do. But when you are listening to some academic type lecture on the mobile, so it is better the man who speaks or talks, he should give some example for the benefit of the listener, okay, for the benefit of audience. So we'll take example of second test. The second test says stay period should be 365 days in the last 4 previous year, which relevant to the previous year, for which we are deciding his residential status. And in the last previous year proper, his stay in India should be 60 days and more. So this is the second test. So 4 years period, 4 previous years period relevant to previous year, we have to take into account. He has been in India for 365 days for last 4 previous years relevant to the previous year, for which we are deciding his residential status as resident in India or not. Okay. So these 4 previous years relevant to the previous year, that we will take example. Take the example that we are deciding his residential status for the previous year 2022. For the previous year 2022. Then count this 4 years period, 4 previous years period for this previous year 2022. His stay, individual stay should be in India for last 4 previous years relevant to this 2022. So 4 previous period means 22, 21, 20, 19 and 18. So he should be in India for 365 days from 2018 to 2021. These are the 4 previous years. They are relevant to the previous year 2022, 21, 20, 19 and 18. So these 4 previous year 2018, 2019, 2020 and 2021, these are the 4 relevant, these are the 4 previous years relevant to the previous year 2022. During these 4 years, previous years, if an individual has been in India for 365 days or more, then he is resident in India. And that second test also contains sub-test. Second test also contains sub-test. And what is that sub-test? Sub-test is that apart from this 365 thing, in the previous year proper, that is in 2022, he should be, he is in India rather, he is in India for 60 days and above. So this is the second test. If while deciding status, if we cannot fulfill first test, then he may take shelter for second test. That second test may help him. Okay. So this is the way his status is decided. So we have learned who is resident. Resident means a person who stays in India, that is first test, who stays in India for period, who stays in India during the previous year for period or 182 days or more. This is first test. And second test, he has been in India, been in India for last 4 previous year, relevant to the previous year, for which we are deciding his residential status as resident or otherwise. Okay. And during the previous year proper, his stay period in India should be for 60 days or more. So these are the 2 tests for deciding his individual status. This is one thing. Now this is all about individual's status. He is resident in India because he fulfilled this test, 1 hour second. Okay. Then what about the what you call HUF firm, then AOP, BOI, all these varieties. What about how to decide their residential status as resident or not? So Act says if their controlling place, management and controlling place of business activities, the activities of firm or this HUF if they are doing business. So this, if their place of management and control of affairs, control of management as well as their control of their management and other activities, if that place, controlling place, is located or situated in India during previous year, we can say that this HUF or firm or that AOP, BOI, it is resident in India. So this is the way to decide the what you call residential status as resident in India or for HUF, firm, AOP and BOI and other things. Okay. Now further company is remaining. We have to know how to decide how to decide whether company is resident in India or not. So Act says if it is Indian company, that is Indian company means company which is formed under Companies Act 2013, under Companies Act 2013. If it is formed under that act, so it is Indian company, and if it is Indian company, then we may you call it as far as residential status of that company is concerned, you call it or decide it as company resident in India. This is first test. Second test for this company to decide its residential status is, second test is, if its registered office is, if it is registered office, or rather I'm sorry, if it is what you call controlling, business controlling place, a place where all key decisions, important decisions to manage the company, to control the company are taken. A place, if that place is in India, and from where the people sitting at the headquarter place, they take the key decision. See, key, word key. Key means very, very important decisions, financial decisions. If that place or people sitting at that place, and that place is in India, so they are all managers. They are the managers, top management people taking decisions to control the affairs of their company. So if that place happens to be, if that place is in India, then company is, you can call that company as company resident in India. So there are two tests. First test is, that is company is Indian, that is what you call form under Companies Act 2013, or then this second test, the place from where this company is controlled, or place from where the top management of that company takes the decisions to manage and control this company. If that place is in India, then that becomes what you call company resident in India. So this is all about company, individual, HUF and all these things, company, this is, we have learned about this resident. Then further we will go resident, individual or company. they have to pay tax as per Indian Income Tax Act 1961. These people have to pay income tax as per the provisions of Income Tax Act 1961 and the provisions of the what you call first schedule of our elder brother of this Income Tax Act 1961, that is Finance Act. First schedule of Finance Act. This company, all these resident people, they, whether individual or company or firm, they have to pay income tax as per the rates given by the Finance Act. Finance Act 19 relevant Finance Act. Each year Finance Act comes from the Parliament and you will find income tax rates in that act. So these resident people have to pay tax as per the provisions of or as per the rates given in relevant Finance Act. This is the feature of resident. He has to pay tax like this. His status we have decided. Then second feature is like this, that this resident in India has to pay tax as per the rates given in Finance Act, relevant Finance Act. Then third thing that legally this resident in India has to, whether it is company or individual, has to furnish income tax return, legally bound to furnish income tax return to the income tax department at the appointed time, or what you call specified date, by specified date. We will learn afterward these dates of submission of return. That topic is also relevant. We will have discussion in due course. So this third feature is like this: they have to legally furnish income tax return. They are under legal compulsion to furnish income tax return to the income tax department. So this, what you call, this is all about resident in India. And I will take another 1-2 minutes of you. Last video, that is this, earlier to this video, we discussed non-resident. We discussed non-resident. In that thing, one or two things I missed while talking on that non-resident. So there are two things. Just please remember. No doubt they are important, but it is better you remember. That two things are like this. First, this fellow non-resident has to pay tax for the income he earns in India. For the income he earns in India. And that tax he pays in India at the Indian rate. So that tax is called withholding tax. Remember this, very what you call thing to be remembered, and this is very what you call wonderful wonderful term, in the sense unique term, and it puzzles us. What is that withholding tax? Normal newcomers rather, basically for newcomers it puzzles. What is this withholding tax? Why not some other name like this? So what I want to say, income tax says when non-resident pays tax in India for his Indian income, so whatever tax is collected, that is called withholding tax. Withholding tax. This you remember. Withholding means withheld for adjustment. Withholding tax means withheld for adjusting tax, because normally this is all provisional taxes. Finally, after submission, furnishing of return, whatever, suppose he has got some what you call total income, he furnishes the return, he has got some income tax liability. From that liability, whatever is paid earlier for this income, suppose so this is India. We'll take case of Indian taxpayer. Taxpayer, they deduct something in advance, TDS. We'll learn this also in due course of time. TDS, they call it tax deducted at source. So this is put in his account only, this credit. Whatever prepaid, it is called prepaid tax. So when he furnishes return to the income tax department, so the department calculates his total tax liability, and from that, whatever deducted during the year, that is TDS, they call officially TDS, tax, that is deducted, that is cut from the total tax liability, and only balance that taxpayer has to pay the only balance amount. So in this case, he being foreigner, non-resident, he pays the tax and goes back to. So there is no furnishing of return. So tax is held up, withheld eternally, withheld eternally. So that way we have to understand. Withhold means, withholding tax means withheld or kept in withheld position. Remember this sentence. Kept in withheld position eternally. Kept in withheld position eternally. Okay. This is one thing I missed. And second thing, this non-resident, if a foreigner, he comes to India and gives some service to the company. Company calls him because their company has taken some technological item or very what you call a highly technical item from that foreign company, and this man, that foreign company's man comes to India, and he or independent man, independent foreign man having technical knowledge, he comes here and give technical service to Indian company here, because Indian company calls him for technical service or technical advice. So that because he is important and gives very valuable advice or service to the company, Indian company, so they are happy with him, and they give him, do him favor in the sense, they say, this is our agreement, as per that agreement you take this amount, service amount, that is whatever service you have rendered, for that this is the fee we are giving you for your service, and we will not deduct any income tax from this, though we are legally bound to deduct this, we will pay on your behalf. So this much favor Indian company shows to person who is a person of weight, having technical knowledge, high technical knowledge. So company pays tax on his behalf also. Okay. So these are the two things I missed while talking on non-resident. Remember this, and this video is not independent. It is continuation of my earlier video on NR, NOR, NRI and resident. So okay, good day, have a good day. We'll meet again with new basic thing. Okay, thank you very much.